In the prior weeks, you were introduced to the discovery process. The deposition is just one method of discovery, but is a very important discovery tool. In this video, we will be covering the different types of depositions, a paralegal's role prior to and during the deposition, and depositions upon written questions. So what is a deposition? A deposition is an out-of-court question and answer session under oath, conducted in advance of a trial as part of the discovery process. It is one of the most important and widely used pre-trial discovery tools. The purpose of the deposition is to uncover and explore all facts known by a party to the lawsuit or by a non-party witness involved in the lawsuit. A party or non-party witness who is questioned during a deposition is called a deponent. There are three different types of depositions we will be covering in this video: the traditional oral deposition, the electronic deposition, and the deposition upon written questions. A traditional oral deposition involves the actual presence of the deponent who responds aloud to the questions asked by the attorney. According to the rules, unless otherwise agreed to by the parties, oral depositions cannot be more than a single day and can only be a maximum of 7 hours. Some advantages of traditional oral depositions include: it gives the attorney taking the deposition the opportunity to see how a witness or the opposing party will perform on the witness stand, and can be used to preserve the testimony of a witness who might be unavailable to testify at trial. If a witness is old or not in good health, attorneys take what's called a preservation deposition to preserve the testimony of the witness. Some of the disadvantages of the oral deposition is that it is inconvenient. Frequently, the deposition must be taken at times and places that disrupt the regular office routine. Oral depositions are also expensive and time-consuming. An oral deposition allows the defending attorney to gain insight into the other attorney's case and strategy, as well as allows deponents to rehearse their testimony before the trial. Such rehearsals often destroy the element of spontaneity. Electronic depositions, or e-depositions, are depositions that are recorded by use of an electronic device such as a digital camcorder, telephone, or internet. Some of the advantages of an electronic deposition is that it saves time and money and can be supplemented by an e-transcript that is synchronized with video imagery. It can also be augmented by a chat room, permitting those who are watching the deposition to talk in private to the attorney asking the questions, and messages can be saved for later access. Some of the disadvantages of electronic depositions include: it is difficult to evaluate the appearance and demeanor of the deponent since it is being done remotely, especially if it is done by telephone. The process is also vulnerable to electronic interruptions and unauthorized listeners who might hack into the transmission of the session. And finally, it requires extra preparation by both the attorney and the paralegal. A deposition upon written question is a deposition before a court reporter that consists of oral responses by the deponent to written questions. Although the deponent is physically present at this type of deposition, the attorney who prepared the questions is not. Instead, he has submitted the written questions prior to the deposition. Rule 31 of the Federal Rules of Civil Procedure regulates the use of this type of deposition. These types of depositions are easy and inexpensive. They are used primarily to obtain business records and testimony from a minor witness whose oral deposition could be very expensive because of the witness's distant location. Although this type of deposition is inexpensive, it does have certain disadvantages. For example, because the questions are written in advance, there is no way to ask follow-up questions based on the witness's answer. Similarly, there is no opportunity to observe the witness during the deposition. Now let's talk about the paralegal's role before the oral deposition. The paralegal may be asked to assist the attorney in preparation of the deposition. Because the paralegal may be handling the procedural details of the deposition process, the attorney will be free to concentrate on developing the substantive legal issues to be explored during the deposition. In the preparation for a deposition, the paralegal may be asked to handle both the notice and subpoena requirements. The Federal and Hawaii Rules of Civil Procedure require that the formal notice of a deposition be given to the deponent and to each party. This notice sets out the date, the time, and the name and address of the person whose deposition is to be taken, and the means by which the testimony is to be recorded. When the attorney taking the deposition is requesting a non-party witness to testify, securing the deponent's presence will be necessary. The legal means for securing the presence of such a witness is a subpoena. A subpoena is an official document issued by the clerk of court commanding a person to be present at the deposition. Once the deposition has been scheduled and notice has been given, the preparation for the deposition needs to be completed. If your attorney is preparing to take the deposition, you as a paralegal have to do a variety of tasks to gather background information and plan the actual deposition. In gathering background information, you will be required to review documents related to the deponent, to develop a history of events that involve the deponent, and to summarize prior discovery pertaining to the deponent. During this step, you may also be asked to prepare any exhibits that may be used during the deposition. If your attorney is defending the deposition, you may want to consult with your supervising attorney and ask whether a preliminary objection should be raised. For example, if your client has been asked to bring documents, records, letters, memos, or any other form of physical evidence, your attorney may, depending on the circumstances, decide that certain objections are in order, such as attorney-client privilege, work product, or some other privilege. The paralegal will also need to prepare the client for the deposition. This will require an initial conference with the client. At the conference, the attorney will explain the deposition process to the client and review anticipated areas of questioning. These conferences should be scheduled well in advance of the actual deposition. Sometimes the witness must be coached on how to act during the deposition, such as answering only the question that is asked, not guessing if the answer is not known, and being encouraged to ask for clarification of ambiguous or puzzling questions. Finally, many attorneys now conduct mock depositions. The purpose of the mock deposition is to help the party or witness prepare for an upcoming deposition. Such preparation will help the client know what to expect when her deposition is taken. The paralegal may be asked to evaluate the effectiveness of the client during the mock deposition. During the oral deposition, the common duties of the paralegal include note-taking, witness evaluation, and helping the witness improve his or her testimony. Note-taking by the paralegal will free up the attorney to concentrate on asking questions during the deposition. In addition to note-taking, the paralegal should follow the deposition outline and ensure that all questions are asked. The paralegal may also use the deposition outline to call the attorney's attention to inconsistent or incomplete answers, or to determine if the attorney's questioning divulges the legal strategy of the case to the other side. When evaluating the witness, the paralegal should look for weaknesses in the deponent's testimony and consider questions such as, has the deponent contradicted himself? Does the deponent seem hesitant about certain aspects of his testimony? How often does the deponent need to refer to notes? Is the deponent intimidated by the attorney's questions? How often does the deponent say he does not remember the facts? If your attorney is defending a deposition, your evaluation will be aimed at helping the witness improve his or her testimony. You may want to keep the following questions in mind when evaluating the deponent's testimony. Does the deponent seem convincing? Does he take time answering questions? Does he volunteer information unnecessarily? Is the deponent argumentative? Does the deponent reply out loud? Is the deponent consistent in testimony? After the deposition, a paralegal will typically assume the responsibility of ensuring the court reporter provides copies of the deposition transcript. The paralegal will also be responsible for reviewing and ensuring the attorney and client review the deposition transcript for accuracy, making corrections, and preparing a deposition summary if requested by the attorney. A deposition summary is a written abridgment of a deposition that condenses the questions and answer period down to a concisely written, understandable account. A properly written deposition summary can organize selected topics or subject matter into an orderly arrangement. A well-drawn summary could also point out inconsistent testimony or missing pieces of evidence. There are three different types of deposition summary formats: page-line deposition summaries, topical deposition summaries, and chronological deposition summaries. You should consult with your attorney on determining which format, if any, he or she wants you to use. Now let's complete this exercise. Review the facts presented in the Alice Bennett matter together with projects number 1, number 2, and number 3, and make a list of the parties you would like to depose. Pick one of the witnesses and prepare some sample deposition questions. The next slide contains a stop sign to remind you to pause the video or refer back to this slide while you complete this exercise. At this point, you may pause the video while you complete this exercise. You may rewind this video so that you can refer to the previous slide. Thank you for watching today's video. Please proceed with completing this week's activities.